Yeah.
Because my sister now
Okay. I have the attendance sheet, but more importantly, I need your name on it. So pass it around. If you happen to be passing it past an empty seat of someone you know is here because their stuff is there, but they're not here, make sure they know about it when they get back. Yes. Yeah. Sorry?
Yeah, we're great.
Did they not
Great.
get it?
No.
That's true. I am supposed to hand you an essay, but I thought they told you to mix it.
We're the only class.
Is that supposed to come from me?
I think.
Will they post it?
No, we sure they didn't. They're supposed to.
So
Yeah.
I
That's their
sent it
job.
to the registrar about 4 days after.
Wow. I would check.
Well, I still have a copy of it. But I'm sorry, I thought they were. Thank you.
You always
All right,
consult.
and I'll fix it. Yeah, I knew I was dragging my feet on the gosh, but I thought you had to make it.
Fridays only or
I'll have to wait for morning again, but I won't wait longer than that. I'll find out what's going on. Well, as a whole class, it's regular, I post. So, yeah. Yeah, you don't want to look at five. And I don't know if I work because I just have the anonymous numbers. But the odds are you did great. Or it's 49. Yeah. I'm sorry, I thought they were okay. It explains why I didn't hear from the five.
People laugh about that.
Okay, yes. Make him feel how?
Weird.
Why would I want to make him feel weird?
Because I make you feel weird. You do it.
I'm not making anybody feel weird, at least not on purpose. Why are you making each other feel weird? Let's all feel good. Not weird. All right. Well, I hope the break was well earned, well deserved. So we're just about finished with chapter 5. Not much to do here. I shut off the slides. That's how finished with chapter 5 I am, huh? But I guess the last no question to consider under the Aleya Ayala. I gotta pronounce that right one of these times, right? Thank you. Versus God was note 3. So and note 3, I built on note 3 already for the next version of the book. So I had some fun writing note 3. But note 3 talks about just the morality of the death penalty in general. So it notes here, Florida law grants a prosecutor the discretion to seek the death penalty for crimes of first-degree murder, felony murder, capital drug trafficking, and capital sexual battery. The laws of many nations, the note goes on to note, the laws of many nations forbid the use of a death penalty. I'm sure you're aware of that. And the beliefs of many faiths are troubled by the use of the death penalty. And I'm sure you're aware of that. For example, the Catechism of the Catholic Church. And if you're not familiar, it's a beautiful document. It helps apply tradition and scripture to various instances that we all face in life. And the Catechism of the Catholic Church states, or at least used to state, because I've updated this note since I published it here in this particular version, quote, the traditional teaching of the Church does not exclude presupposing full ascertainment of the identity and responsibility of the offender, recourse to the death penalty when this is the only practicable way to defend the lives of human beings effectively against the aggressor. And that's paragraph 2267 of the catechism, or at least that's how it used to read. As I mentioned, I've updated this note to reflect the update to the catechism. But before I wrote this, that I just quoted you before that update, and likewise, Bill Piat, hope I'm pronouncing that right, Piate, he's written a fantastic casebook. I don't know what law schools they teach from this casebook, but I would love to go to one of those law schools. It's called Catholic Legal Perspectives, and I'm stealing a quote from page 185 of his second edition, year 2015. He said there, and again, this was before the update to the catechism, quote, while the Catholic Church does not condemn the death penalty as intrinsically evil, because of the Church's high value of human life, the circumstances under which the death penalty is morally acceptable are rare, quoted Bill Piat. And as I mentioned, the catechism has been updated. I have to paraphrase it because I don't have the latest language, but under Pope Francis, the death penalty is inadmissible. Inadmissible, I believe, is the word used. And in other words, without using words such as intrinsically evil or morally wrong, the catechism now reflects that the death penalty should not be used, that it's inadmissible, that it's not an admissible form of punishment. So I don't know, one might argue that that's a change in church doctrine. One might argue that it's not. One might just argue that that's a reflection of the fact that the justice system is what it is, that if there was a deterrent effect to the death penalty, and I'm sure scholars can debate whether or not there was one, but if there was a deterrent effect to the death penalty, perhaps that same level of deterrence can be achieved in a properly functioning criminal justice system without turning to the death penalty. Perhaps this is part of the explanation, if there is an explanation, as to why the death penalty is inadmissible. But certainly the catechism in its current state, as I understand it, reflects the fact that the death penalty is inadmissible. So from there, I ask in the note, what are your personal beliefs about the death penalty? And of course, ask a very difficult question when I ask that. And I ask a question that could change over time, you know? Perhaps I would have answered that question differently at a different period of time than I would answer it now. But for those of you who are daring enough, I saw 2 hands go up already. I saw 3 hands go up. Who was up first? Okay, you were up first, sir, says the crowd.
I think where there's compelling and substantial evidence of an egregious murder, then I would support the death penalty.
Okay.
But
So if I'm hearing you right, you would support the death penalty, but you've got requirements. You've got requirements as to evidence.
yes,
You need some sort of overwhelming evidence, and you need some requirements as to the circumstances. You're talking about a particularly egregious act.
yes.
Okay.
So one of the challenges is that I don't think circumstantial evidence, for example, is sufficient. There have been a number of criminal prosecutions where it just made it has been ascertained where people have been on death row for an extended period of time, and then it turns out that they were not guilty. So when you have compelling evidence, as in the case here, the one case that was transferred over to King, past law enforcement person, that would have been an easy case, even for me, in seeking the death penalty.
So those facts you see as meeting the standard you believe is appropriate one for imposing the death penalty.
So I'm saying the discretion is good, and there are certain situations under which you could exercise discretion. But there are certain cases that are so egregious that I think when you look at the different tiers of punishment, retribution in terms of the death penalty is really appropriate.
I think I see your point. Yeah, I think you're making your point clearly. Yeah. And which hand was next? Oh, good, another hand. Yep, I won't neglect you, but let me get these 2 hands first. Yes.
Well, I take 3 issues with the death penalty. 1, I think it's the easy way out for the offender, obviously. 2, it's pointlessly expensive. It's a long, drag-out process that takes decades usually to actually impose the death penalty. And 3, I see it kind of imposed pretty hypocritically. States that mostly defend the death penalty or tend to be states that are like, yeah, small government all the time, but there's no a bigger government than forcing somebody down, putting a needle in front of them and taking their life.
Right. So the first point you made was easy way out. And Joe, an easy way out for the perpetrator,
Yes,
for the guilty person.
yes.
And I see what you mean. Instead of having to stay here and
Rather than
live
on it.
on this earth with the burden of knowing what they've done and the punishment of having done it, you see it as an easy way out for them.
Yeah.
And then your second point
It's expensive.
is the expense for the state. So the expense of the death penalty, the expense of life in prison, which expense?
The expense of death penalty,
Yeah.
putting somebody's life in prison is a fraction of the cost of putting.
Is that what the statistics show?
I
Yeah.
think so.
Okay, all right. Get some agreement on that.
Multiple appeals, it just kind of keeps dragging on the legal process, and the death penalty, I forget the statistics, but I know it's in the millions of dollars to try to
Wow.
these.
Okay,
And that burden gets put right on the taxpayers.
yeah. And the third point you raised was one of competence of the government. Is that a good way to paraphrase it?
I guess.
Okay, maybe not. But help me paraphrase your third point better.
Well, mostly states that support the death penalty tend to be states that are in favor of smaller government.
Okay, so you see the politics of pro-death penalty, if there's such a thing, states as being one that's like pro-government.
I see states that want to impose the death penalty as being hypocritical because they want a small government, but
They're
I think it takes a
hypocrites.
big government to actually kill somebody.
Yeah. And gosh, has anyone ever seen a government program that simply wasn't run well enough? Has anyone ever seen that? And anybody seen someone get lost in the system or a government program not function fully adequately? You know, if we can't trust government with these minor things like getting a check out on time or getting my driver license photo perfectly squared in the page, should I trust them with life and death? You know, it's a good question. There was a third, and yes,
I agree with what he said,
so you agree with all three points?
No, but the overwhelming, there should be overwhelming evidence that
Okay,
you're gonna kill someone. I just wish they would speed it up. I think that, if there's overwhelming evidence that you're guilty, that you did it, then like within 6 months, you should be just done with it.
okay. So you're in favor of a high evidentiary burden, but you're also in favor of a streamlined process. Okay, yeah. And your point was well taken, I think, with the cost and expense of appeal after appeal. As a board certified appellate lawyer, I don't know that I would be hypocritical if I talked about the cost of an appeal, but
But he's right, it's like, I think the minimum is $1 million to kill someone.
Enforcing the death penalty costs
Yeah.
Florida $51 million a year above what it would cost to punish all first-degree murders with life in prison without parole.
wow,
And
okay,
that's from the Supreme Court.
wow.
Because of the appeal process, that's why.
Wow.
Attorneys that get paid.
And you had your hand up.
Well, to his point, in general, speaking like countrywide, like most people will die of natural causes before they're get executed.
Wow. Is that what the statistics show? Yeah.
Yeah, and they sit on death row. Death row is a lot easier to serve than you can just get life in prison. Life in prison is not an easy sentence. And I do agree that,
So you see a big deterrent effect with the punishment of life in prison.
well, I think I'm in the state attorney's office this semester and sitting in court every day. I think
Yeah.
when you watch someone get 1, 2, 3 life sentences without parole and you see how that affects them, I think that's a much harsher punishment than death.
And do you see the accused viewing it the same way when you're working at the state attorney's office? Are they
No,
equally concerned?
I'm definitely not as harsh as people are here. I see
Okay.
them as individuals who made mistakes.
Oh, no, I understand that you see them as individuals. What I'm wondering is, when you say life in prison is worse,
It's harsh.
from your perspective, does the criminally accused understand that? Do they know that?
And I've seen someone and
You
like
you say, yeah.
realizing that his life is over and that's what it's gonna be. And that reality is very powerful. I mean, I think I'm a better person and I'm more lenient today. And I think that, it's
So it
good to
changed
know
you?
that-
This experience changed you?
Yeah, I think so. But I think that, even the death penalty where everything was there, it's like definitely, well, Marky Boyd, which was the person, he was tried here last year and they sought the death penalty and the jury gave him life.
Wow.
They said no.
Wow,
they spare him, so
that was the outcome.
it doesn't even matter.
There were 2 hands up, maybe yours.
I mean, in general, they're pretty clever, but my pushback is my own experience. When you have somebody on life imprisonment from my former job, I've seen where these people now know that, hey, I have life imprisonment, and they do some of the most crazy things. They kill people. What are you gonna do? Give me another life in prison. And they're just there, and they just feel like, now I can take advantage of the system. What am I doing? I have nothing to lose. I'm here for, 300 years. So, I'm just gonna kill somebody again.
So you're arguing at some point the deterrent effect is
Yeah,
lost.
yeah, so at some point,
Yeah.
I think I agree that at some point you find a way to get it more expeditious. Just get rid of it.
Yeah, and you're agreeing with the point that dragging out appeal after appeal after appeal for decades is a problem.
Absolutely.
Yeah. Did I miss a hand? Thought I had a hand over here. Okay. Yes.
It makes me really nervous when I say court systems be expedited.
Yeah, the expedited and court system don't often go together well. Yeah. I hear you. It's like jumbo shrimp. Which one is it? Is it jumbo or is it shrimp?
I like it.
Okay, I like shrimp. That's why I use that analogy. But thank you. It's an important point that I wanted to cover. And that wraps up our chapter 5. We've got a few minutes left in class. And have you noticed we're ahead of the syllabus? Has anyone taken note of that? Yeah. Well,
You're off next week?
No, because we had one class canceled. So noting that this is our 6th meeting, not our 7th. We're ahead of the syllabus. Have we noticed that? Okay, and I like to do that. I like to try to get a little bit ahead of the syllabus because that carves out some time in our last class that I can use to review for the final exam. So I hope that's okay with everybody.
Fantastic.
So please note that for the syllabus, we're a little bit ahead of the syllabus. Another thing to note on the syllabus is at the end, we cover multiple chapters in one class. And I hope that doesn't offend anyone. But the fact of the matter is that some of the material is more important than others. So I put the more important material first, and I cover it in greater detail. I put the less important material at the end, and I cover it in less detail. And I guess the argument could be made, well, why not spend just as much time on the unimportant as you spend on the important? But I've found in life, when I spend more time on things that are important, and less time on things that are not important, that I have a more successful life. So hopefully, that applies here in the classroom too. But we've got 10 minutes, and what I want to do is start chapter 7. Chapter 7 talks about separation of powers, and it launches from the prior chapters. Yeah, I need to not waste this time, so I can either cut up chapter 6 or I can cut up chapter 7. Chapter 7 cuts up very well, chapter 6 doesn't. So I'm gonna cover a little bit chapter 7 here with the remainder of this. I know, but I'll cover a little bit here. And then next class, we're back on track at chapter 6. Then the class after that, we'll finish chapter 7, start to cover chapter 8. Chapter 7 talks about separation of powers. And separation of powers is a concept that is implicit to our federal constitution. If you search the text of our federal constitution, I dare say you won't find the word separation of powers. However, if you search the text of our state constitution, you will find those words. Florida's constitution, quoting from section 3 of article 2, says branches of government. The powers of the state government shall be divided into legislative, executive, and judicial branches. No person belonging to one branch shall exercise any powers appertaining to either of the other branches, unless expressly provided herein. And therein lies the rub. That's the important takeaway. Unless expressly provided herein. Unless. Now you'll notice the end of chapter 5 that I didn't cover talked about quasi-executive power. You notice the end of chapter 4 that I didn't cover talked about quasi-legislative power. And you'll notice at the end of chapter 6 that I won't cover at the time of covering chapter 6 talks about quasi-judicial power. I will come back at the end of chapter 7 here, cover those 3, those quasi-powers. That is the takeaway. That is the difference between a violation of separation of power and not a violation. The fact is that the Constitution says in Article 2, Section 3, unless expressly provided herein. So the Constitution contemplates that you might take the powers of one branch and share it with the holder of an office in the other branch. You have not, NOT, you have not identified a separation of powers violation simply because you've identified someone elected into one branch of government exercising the powers of another branch. There are times when that is permissible. So what is the standard? How do we know when there is a violation of separation of powers? And we know that because we're looking for two things. We're looking for a violation of the doctrine of encroachment and/or a violation of the doctrine of non-delegation. So the first one is encroachment. And if you're putting that in your notes, that's ENCHROCHMENT, encroachment. And the second doctrine was non-delegation, DELEGATION. And in my notes and questions to consider, I quote from a case that I'd rather not even cover, Bush versus Shiloh, Florida Supreme Court 2004, that talks about the encroachment and the delegation. Florida has traditionally applied a strict separation of powers doctrine, says Bush versus Shiloh, Florida Supreme Court 2004. This doctrine encompasses two fundamental prohibitions. The first is that no branch may encroach upon the powers of another. The second is that no branch may delegate to another branch its constitutionally assigned power. So there are the two standards, the two definitions, if you will, of the encroachment doctrine and the non-delegation doctrine. We don't have much to go on here when we say the encroachment doctrine means that no branch may encroach upon the powers of another. It's kind of like defining a word by using the word. It doesn't tell you much. That's like saying, well, the word is means that something is. Okay, thanks. Didn't give me a lot to go on there. But we do have something to go on when it comes to the non-delegation doctrine. No branch may delegate to another branch its constitutionally assigned power. It's constitutionally assigned power. So first we have to find that that particular power has been assigned to a particular branch. And when you look at the quasi-powers, you find that they weren't assigned to a particular branch. For example, the executive branch can set up agencies. We just studied the executive branch. We saw at least 4 agencies that were created with members being the governor and his cabinet. Other agencies exist. What if you have a dispute with one of these agencies? Well, for the most part, you'll have to seek an administrative remedy under the Florida Administrative Code, Chapter 120. When the agency makes a decision and hears your case, the agency might find that there are disputed issues of fact. If so, then the agency is obliged under Chapter 120 to hold an evidentiary hearing. So you'll have someone who's not a Florida Constitution Article 5 judge. You'll have someone who's a member of Article 4 of the executive branch, such as a Division of Administrative Hearings hearing officer, or a workers' compensation judge with compensation claims, or some other title for an individual who's not a judge under Article 5 of Florida's Constitution. And that person will hear evidence, will rule on evidentiary objections, and then make findings of fact and propose conclusions of law. Wait a minute. That person's acting like a judge, right? They're finding what documents come into evidence and which don't. They're hearing the witness testimony. They're ruling on objections while the testimony is being made. And at the end, they're declaring what the findings of fact are. They're making findings of fact. They're offering proposed conclusions of law. That sounds like a judicial function. Well, it is. But it's quasi-judicial because it's happening in the executive branch. The Constitution allows for it, and therefore you do not, NOT, have a violation of constitutional separation of powers. So the first thing we note as we look at the separation of powers chapter is that it is more complex than it seems. We can't simply find, oh, that looks judicial and you're not a judge, therefore you violated the separation of powers. We need to find a violation of either encroachment or non-delegation. Without such a finding, we don't have a separation of powers violation. So that's the perspective I want you to take as you read chapter 7, which I know you will. And you're going to look at a couple of cases there, which I hope you find interesting. The first you're going to read is a dissension among the branches example called Florida House of Representatives versus Crest. This is a 2008 case from the Supreme Court of Florida. It's a joy to read. Curl up with it and enjoy it. It's written by one of the great Supreme Court justices of our time, Raul Cantero, who subsequently quit the job and now is in private practice. I'm sure his clients are happy that he did that, but as for the rest of us Floridians, I wish he'd stayed on the bench because he's a great writer. As you study federal constitutional law, you see many examples of great writers on the U.S. Supreme Court. Unfortunately, as you study state constitutional law, you rarely see examples from state to state in the state high courts of those who have brilliant writing skills. But there are some, and this gentleman is one of them. So enjoy Florida House of Representatives versus Crest. What it talks about is 16 years of sporadic negotiations. There was a federal IGRA, a gaming act. Federal law said that the state of Florida had an obligation to negotiate with sovereigns, specifically Native Americans, to spell out the terms upon which gaming could take place on sovereign Native American land that happened to be within the jurisdictional boundaries of Florida. But over 16 years, Florida's legislature never got it done. So this particular governor in this case finally stepped up and cut a deal he thought was a good deal for the Native American sovereign nation. They must have thought it was good too because they entered into it. And a good deal for the state of Florida. But what happens? Marco Rubio, then Speaker of the House of Representatives of the Florida House of Representatives, files a lawsuit on behalf of himself and on behalf of the Florida legislature with the Florida Supreme Court suing the governor. So look at this showdown of separation of powers. The judicial branch, Supreme Court of Florida, is hearing a case of the legislative branch versus the executive branch. As you read the case, note some of the takeaways. For example, what does the case tell you when it comes to who in this fight ultimately decides what the public policy of the state of Florida is? Part of the fight came down to what is the public policy of the state of Florida? Did Florida Supreme Court say, hey, y'all came to my court, I will tell you the policy of the state? Or did the Florida Supreme Court adjudicate that one of those other two branches of government, the executive or the legislative, was the source of public policy for the state of Florida? Read the case, take a note, find out what the answer to that question was. After that, you'll see another very interesting showdown of a potential violation of the separation of powers. What you're going to see are two related cases I put under cooperation among the branches. The first was the List versus Crane Company. This came out in 2018, around December, if I'm not mistaken. And that was followed by In Re Amendment to Florida Evidence Code, which came out in May of 2019. What you see the Supreme Court of Florida doing in May of 2019 was recalling the mandate and undoing, revoking, withdrawing the decision made in December 2018. What happened in between? What was the big difference? Did we amend the state constitution? No. Did we change the Florida statutes? No. We had a change of personnel on the Supreme Court of Florida. But is that the full explanation as to why DeLeese versus Trains Company was overruled by In Re Amendment to Florida Evidence Code? The question I want you to explore as you read those two cases is this. Who has the authority to determine the rules of procedure and evidence here in the state of Florida? Is it Florida's legislature? Is it the Florida Supreme Court? Who has that authority? I want you to take a look at those cases and figure it out. And ultimately, as you review our separation of powers chapter, what you need to come to an understanding of is how to explore whether there is a violation of separation of powers. It is not uncommon, indeed it is very common on the Florida bar for an essay question to raise a separation of powers issue. So learn how to spot whether there's a separation of powers issue. Learn the legal standard that applies to whether the separation of powers has been violated. And learn how to articulate yes or no, whether there is a violation. That'll be a valuable skill to you in practice and an invaluable skill to you in taking the Florida bar exam. So with that background, please read chapter 7. We won't be covering that next week. Next week, we'll be covering chapter 6. Chapter 6 talks about the judicial power. After we cover on March 17th, our next meeting, chapter 6, the executive power. Then on our meeting after that, we'll return to chapter 7, separation of powers, and we'll also be covering chapter 8, sovereign immunity. Some of the chapters are shorter than others. Those shorter chapters may not need an entire 2-hour, 120-minute lecture to cover. So for next week, which chapter are we reading? 6. For the week after that, which chapters are we reading? 7 and 8. Oh, you got it. Until then, Bernadette and I will keep each and every one of you in our prayers. If you happen to be the type to pray, please pray for us. May God bless each and every one of you. Thanks for taking my class season.
Bye, Carlo.
Does anyone